you so much for joining us this morning. So today we have Don Hicks from Sheakley. I'm going to pass it over to him, but thank you so much for being with us here today. All right, thanks, Don.
All right, thank you, Pam. Again, good morning, everyone. Thank you for joining. For those that are on the webcam, I hope you can see me okay, and those that aren't, I hope you can hear me okay. So thanks for joining. I know. And I will be happy to stop and answer any questions. And then I will have my contact information at the end. So if you want to reach out to me directly, I will be happy to help out. So no cost whatsoever. So, okay, let's talk about Ohio's unique system. Ohio is one of 5 states in the country that are considered monopolistic. And you may have heard that term before. Monopolistic means only that the workers' comp is managed and controlled by the state. You can't go out and shop workers' comp in the open market with an insurance company. You have to go through the state, or if you are big enough, large enough, you can self-insure your workers' comp on your own, but that is really reserved for larger companies, 500 plus employees. So with that, by it being so unique, there are different components to workers' comp. You have the Industrial Commission, which is the entity within the workers' comp system, the BWC, that handles disputes. An injury took place and there's some type of dispute. So the Industrial Commission, downtown Cleveland, hears those cases and resolves those disputes. Sometimes in favor of the employer, sometimes not in the favor of the employer. The BWC, everyone knows about the BWC. It is run by the state of Ohio. This is the part, the next two, the MCO and the TPA, that most people get confused, and rightly so. It is very confusing. The MCO, the Managed Care Organization, handles primarily the medical portion of an injury claim. The medical portion of the injury claim. So looking at things like prescriptions as a result of an injury, doctor's appointments, physical therapy, those type of things. When a worker is injured, the Managed Care Organization manages and handles that. And they work in concert with the TPA. The TPA, third party administrator. In the state of Ohio, you are required to have an MCO. You may know your MCO, you may not know your MCO. If you haven't actively selected an MCO, the state of Ohio randomly will assign one for you. It is part of the premiums that you pay. An open enrollment for MCO changes happens every 2 years. It was supposed to happen this April or May. It did not because of the pandemic. But MCO changes will happen next year in 2021. So everyone that's a private employer in the state of Ohio, you have an MCO. The third party administrator primarily works with the employer. And we're going to talk a little bit more about what a TPA should be doing in representing your workers' comp program. You have different sponsorships like the BBB, like chambers. You have to be part of a sponsoring organization, which equates to the BBB, in order to get certain discount programs and so forth. So that's another party to the workers' comp system. And then obviously you have the injured worker or the claimant, and the if they have an attorney that you have to deal with. Workers' comp in the country is what they call an exclusive remedy. Exclusive remedy. That is a legal term. So if any attorneys are on the call, you know exactly what I'm talking about. Basically what that means is that instead of the courts being bogged down with lawsuits, and individual lawsuits and disputes and so forth, the BWC, through a federal system, has an exclusive remedy, and all disputes and claims and injuries are processed and adjudicated through the workers' comp system. And that legal term is exclusive remedy. So in exchange for working in an organization, the employer is required to pay their premium for that insurance coverage. And when an injury takes place, that claim is managed, and the employer sometimes has to pay. Obviously, they have to pay their premium. So just a little legal jargon for workers' comp. Then, in really serious instances and situations, you could have private investigators involved in a dispute. We see that quite often. IME stands for Independent Medical Examiner. So, for example, you could have an injured worker that says they injured their back at work. They will go to a chiropractor, and that chiropractor will say, Don injured his back. He's going to have Vicodin for the next 6 months, and he cannot lift more than 5 pounds for the next year, as an example. Well, an independent medical examiner can subpoena the medical records of that chiropractor and release their own independent judgment. Is that valid or not valid? So you need to know that, and you need to make sure that if that is a service that you need, that your third-party administrator has expertise and resources to provide that judgment. Because that independent medical examiner, when you go in front of a hearing, can present that evidence, and it can help you in winning your case and controlling your workers' comp cost. And then you have occupational therapy or vocational rehabilitation, where an injured worker can do other work within the organization while they are healing or while they are recuperating from an injury. So workers' comp, it is complicated. So there are multiple parties involved in workers' comp in the state of Ohio. And this graphic is designed to sort of graphically tell you or graphically display all the parties involved and how that works. So a worker is injured, they go to urgent care, the emergency room. The nurses and doctors and staff are trained to say, is this injury a result of a work-related injury? And once that answer is yes, that starts a paperwork claim process that goes through from the providers, the hospitals, to the managed care organization, back to you, because you have to report it, right? And then to your third-party administrator to provide that consultation on that claim. If it is a dispute, the injured worker may hire their own attorney, and it is then taken to the industrial commission to make a ruling on that dispute between the injured worker and the employer. Sometimes witnesses are involved, attorneys are involved, and so forth. So that is a very, very complicated system. Now, you may already know this. This is basic workers' comp, but there are really 3 main components when it comes to workers' comp. The first is lost time. So any lost time, meaning the employee cannot work more than 7 days, is a lost time claim. So the wages that employee would work normally goes against your claims history. Lost time, so lost time claim. So salary, compensation. The third component of workers' comp is the medical portion, the medical claim, the surgeries, the medical equipment, the prescriptions, anything related to medical is the medical portion of a workers' comp claim. The third component, and is one of the most confusing components, are reserves. A reserve is money set aside by the state of Ohio to cover any future surgeries or medical care that an injured worker may need to go through. So you could hurt your back today, but a surgery may not happen for another 6 months. So the state of Ohio will set aside, I don't know, $30,000 until that surgery is done and taken over. Goes away and completed. That is part of your claims history. Your claims history is like a credit report, if you will, for workers' comp. And then the fourth component an asterisk on this. We're going to talk a little bit about this today, but it's subrogation, another legal term. Subrogation means that an injury happened because of the fault of a third party. It could be you're in a company vehicle, you're going through an intersection, and someone T-bones you. Well, that's no fault of you as the employer or the injured worker, but the driver at fault, their insurance company is responsible for that. You can also have subrogation if an injury occurred because of a faulty piece of equipment. So if you're in a plant and you're working on a machine and that machine malfunctions, well, it's no fault of the employer, it's no fault of the employee, but whoever the manufacturer is at fault, and they will take on the responsibility of that workers' comp claim. So all of this is something your TPA should be looking for on your behalf. Now, TPA Services, again, a third-party administrator. What should they be doing on your behalf? Obviously, the biggest thing from a cost standpoint is making sure that the TPA is pulling you together to get discounts. The max discount on your premium that you can get in the state of Ohio is 53%. 53%. I remember the days, 2008, 2009, and before, it was in the 90%. But now is 53%. So your TPA should be grouping you together for group rating discounts, which is the upfront discount. So instead of your premium being X, it is a percent less than that by being in a group program. And group means industries. So all transportation companies are grouped together, manufacturing is grouped together, and so on. A group retro program is a retrospective program, meaning you don't get the upfront discount on your premium, but in the future, they will retrospectively look back and issue you a rebate. All of those discount programs, you have to have a TPA in order to qualify. Winning early battles is one of the biggest things that most TPAs don't pay enough attention to, is how do I get that claim off of my experience in the first place? How can I prevent injuries from happening in the first place? And we're going to talk about some strategies as we go through this. Projections and budgeting. Your TPA should be doing some of the financial analysis for you, making some, providing you with some consultation around what your costs are going to be, not only in the current policy year, but in the next policy year. So they should be helping you with that. And most importantly, advocating for you. Advocating for you. That is absolutely critical when it comes to workers' comp. If you have a TPA that you're just reporting a claim happened and you don't hear from them, they're not looking for ways to mitigate that claim, you may want to look at another TPA. That's obviously that's up to you, but they should be absolutely advocating on your behalf. And that is something that we do at Sheakley. That is a business strategy and a business model of Sheakley. So let's get into winning the early battle. What does that look like? Well, we talked a little bit about the independent medical reviews, okay, the IME, the independent medical examiner. That is what the strategy is to prevent or mitigate a claim from appearing on your history in the first place. Okay, that is the goal. The first goal, obviously, is to prevent an injury from happening in the first place. But when an injury does take place and a claim is filed, how can you win that early battle so you don't have to deal with it? We talked about medical releases, subpoenaing medical records for doctors and prescriptions that are prescribed to an injured worker. Are they legitimate? Are they valid? Are they appropriate? So medical releases is important. Early settlements. A settlement is where an injury took place, okay? You can project what that cost of that claim will be. If that claim, for example, is $100,000, well, you may want to look at selling that for $10,000 as an example. So that does not appear on your history. And your TPA should be doing a financial analysis, says, listen, if that $100,000 claim is on your history, it will have the impact of increasing your premiums by 120% for the next 5 years. That equals X, versus 10,000 and that claim goes away and that the injured worker agrees to it. That's going to be a lot more cost effective for you. So your TPA should be counseling you through that and doing some of that financial analysis on your behalf. Modified duty. I do not see enough of this in the marketplace. Modified duty is, instead of a worker doing their normal job duties, they would do something else while they are injured. So it could be working in the office, working at a charity, doing some other type of work that's appropriate, so that injured worker is not sitting at home. I see way too many injured workers that are just sitting at home. And it's no fault of theirs. I'm not suggesting that. But the more they are disengaged with your organization, the harder it is to get them back to work and keep them engaged. There is a psychological thing that goes on when a worker is injured. Financials, ego, all of that stuff, culture. You know, when a worker gets injured within your organization, it can impact your business reputation. And families and workers want to make sure that they are working for a safe company. So getting that employee back to work, doing some type of other work while they are healing and rehabilitating, it helps control your cost, and it helps keep that employee engaged in the workplace, and it helps with productivity. So something to think about. Attorney recommendations. So when you get that summons in the mail that one of your employees, whether they are a current employee or a former employee, dealing with that is something that your TPA should be giving you some counsel and advice. Your TPA should not be giving legal advice unless they are qualified. I'm not suggesting that, but give you some best practices and so forth to help you deal with some of that legal. It's very scary. And I have seen some of the worst workers' comp claims that you can think of. So winning some of those early battles is very important. And your TPA should be counseling you on drug safety programs. There are two types or two categories of drug safety programs, a basic level and an advanced level, that will give you an additional discount on your workers' comp premium. The basic level is a 4% discount off of your premium, on top of your normal discount if you qualify for it. And then if you did random drug testing, I think it's a 7% additional discount. So your TPA should be rolling out drug safety programs to make sure you are maximizing your discount and keeping your employees safe, and help with the culture and the morale within the organization. Any questions, Pam? No?
No questions so far.
Okay, very good. So how do you reduce a claim? What are some ways to reduce a claim and the impact of that claim on your credit history, if you will, or your workers' comp history? Some people call it loss history. Some people call it claims history or claims experience. Whatever term, all of those terms basically mean the same thing. I liken it to a credit history. But the first one is a handicap reimbursement. I personally do not like that term, handicap reimbursement, but that is the technical term from the state of Ohio. Basically what that is is a pre-existing condition. And let me give you an example. Let me take a step back. There are, I think, 26 recognized pre-existing conditions that you and your TPA can apply for to reduce that claim impact on your experience. And let me give you an example. You have a worker, you have a plant, and they are working on equipment in this plant. In the middle of this plant is a stack of pallets, wooden pallets. You have an employee that is walking from one workstation to another workstation within the plant. As that employee is walking by the pallets, they fall, cut their knee on a pallet. A workers' comp claim is filed. And the question becomes, on the face of it, is that a workers' comp claim? And most will say yes. And there's no dispute that a claim happened, okay? But what if after looking at medical records, we talked about that, right? That as that employee was walking next to those pallets, they had a heart palpitation, for a few seconds, lost oxygen, and it caused them to faint as they were approaching those pallets. Now the question becomes, no one is disputing that a claim happened and a worker got injured, but that was caused by the heart palpitation, not by the pallets. And that is an example of a handicap reimbursement. The injured worker still gets care, but the state of Ohio pays for a portion of that claim, not the employer, okay? The most common is arthritis, diabetes, and heart conditions, and there are others. Now I will tell you, as soon as this training is over, and if you are not familiar with that, you should call your TPA and see what kind of experience they have in handicap reimbursements. And more importantly, if they say, yes, we do that, the next question should be, what is your success rate? And you may be surprised at that answer. It's a very difficult thing to do. Your TPA needs some expertise in this, but it has a huge impact on your claims going forward, okay? We talked a little bit about at-fault drivers, okay? At-fault malfunction of equipment. We talked a little bit about settlements and a claims max value. I don't see a lot of this. You know, for example, there's a 15K program, 15K program, meaning that the employer will take the responsibility for the first $15,000 of a medical claim. And in exchange for taking on some of that financial liability, they get a lower premium. In most cases, it's too much out-of-pocket risk when you compare the potential decrease in the rates. In a lot of cases, it don't make a lot of sense or doesn't make a lot of sense. But those are some examples. Wage continuation is another, meaning you agree as the employer to continuing paying the salary of an injured worker. And sometimes they can lower the impact of a claim. So just some ideas to reduce the impact of a claim on your experience. Now, a few things that your TPA should be doing for you. Providing notices, making sure whatever you do, do not lapse your installment payments, even if you do not agree with them. If you are disputing your invoice, don't just do not pay it. Pay it, and then if there's something in error, they will issue you a credit. So I have seen some companies not pay their premium because they are disputing, and then their policy lapses. And guess what happens almost the day of a policy lapse? Yeah, someone gets injured, and now you don't have coverage, and that is not good. You do not want that. And then true ups. True ups and the reconciliation happens every August, and your TPA should be helping you through that. You are required as an employer to reconcile your workers' comp every August. So maybe your accountant is doing that. Maybe you are doing it with your payroll company. Maybe you're doing it yourself. It is a real complicated process, in my view, but someone should be helping you with that. But make sure you do your true ups. Reminders, manual code audits, making sure that all of your classification codes for your workers' comp are correct. You know, the 4-digit code. Is that correct? And does that apply to your industry and your job descriptions? By the way, if you do not have an employee handbook and job descriptions, in most cases, you are exposing yourself to a lot of heartache, particularly when it comes to a workers' comp claim. In most cases, particularly if the injured worker's attorney is involved, that is going to be one of the first things that they ask for. And if your policies, job descriptions are outdated or you don't have one, it creates more doubt. You know, for example, if someone cannot lift more than 30 pounds and they go and lift something more than 30 pounds, but they have acknowledged a policy where you told them they can't do that, that helps you. Versus if you don't have anything, it's not clear to the injured worker, it's not communicated to the organization, it can cause some heartache. So look at your employee handbooks, look at your job descriptions, reach out to me if you have any questions, but make sure those things are updated, make sure that they are legally vetted, and make sure that it matches what the goals and objectives of the organization is. Okay, we talked about the appeals process. Your TPA should also be looking out for any type of rebates or refunds that the state of Ohio is giving. Safety grants. Safety grant is where for a particular industry, if you purchase a particular piece of equipment, the state of Ohio will give you a grant for that. So your TPA should be giving you some counsel and advice for all of that. The BWC, the state of Ohio, the Governor DeWine asked for the state to have another billions back refund from the board of directors. That was probably 3 weeks ago. I'm not sure where that stands, but if that is approved, some of those checks should be going out next month. So your TPA should be keeping you up to date on that and making sure that if you are eligible for a rebate and a check, that those checks are actually getting to you. So, by the way, if you get a check from the BWC, a valid check from the BWC, cash it. Okay, that is money to you, and they do track to make sure that you cash those checks. If you don't, they will contact you. So, good piece of advice there. Okay, how do you prevent claims? Well, we talked a little bit about that. Is transitional work or modified duty, light duty, and having a very aggressive return to work program. Here at Sheakley, I can speak to what we do. Sometimes people will say, well, I don't have the accommodations for light duty because of the way my business is run, the job responsibilities for my workers. I don't have anything else for them to do, and that's fine. I know that, for example, Sheakley, we do partner with Goodwill, Salvation Army, those type of organizations, to where when someone is rehabilitating, they can go work at a charity. And we do that all the time here at Sheakley. And that helps lower your claims, keep the employee involved. And if it's a claim that may not be legitimate, you'd be surprised how that claim goes away when someone doesn't want to do another type of work. So it's a way to sort of keep the employee engaged as well. But whatever you do, have a transitional work program in place. Make sure that it is communicated, understood, and acknowledged by your existing staff and any new hires that you hire, okay? Again, going back to those job descriptions, employee handbooks, your safety policies, all of that is a strategy to sort of help keep your employees safe, but when something does happen, you can follow the procedures to and a strategy to get that employee back to work. Telemedicine, telehealth, teledoc is becoming very, very popular now, particularly with the pandemic. Virtual healthcare through the phone or video or iPhone is becoming very, very popular now instead of having to visit a hospital, and in-home rehabilitation and so forth. So the second one is workplace safety. Again, this is the biggest area of risk. How are we doing on time? Pretty good. This is the biggest area of risk that I see for most organizations, where they are not doing this, and they are not doing it to the extent that they should. I'll be completely frank. Some companies are really doing a good job by doing things in-house, providing toolbox talks, trainings. The problem I see with that is, particularly for smaller companies, when I say smaller, I mean number of employees, usually who's doing the training is wearing multiple hats. They're doing so many different things within the organization, and they're doing a little bit of safety because they just have too much on their plate. Things get missed. Regulations that you should be paying attention to gets overlooked. And it's not negligent, you just don't have the time to do it. I tell you, it is better to hire an outside firm that specializes in safety for your industry to do that for you. And in most safety programs, it's not very costly relative to the impact it could have to your organization. So really consider, instead of doing it in-house, to hire someone to do it, or hire a third-party firm to support whoever may be tasked internally to do your safety programs for you. I tell you, hire their experts. It is worth the investment long-term. OSHA assistance, OSHA reporting, pandemic and RTW's return to work. We talked about policy writing, CPR, first aid. I can't speak to the industry, but I know at Sheakley, we do have CPR classes that we give to our clients that are done virtually. So we will deliver the mannequin, the dummy. We will set up a webcam, and we will videotape and do training virtually, and see people doing their CPR compressions and their breathing virtually because of the pandemic. But CPR first aid training. By the way, in your organization, do you have I forget what you call it, the heart machine, the AED, the defibrillator? Do you have one in your organization right now? When you're on break, go look and see, do you have one? Do you have a first aid kit or kits in your organization? If you don't, get them. Because if someone has a heart condition, that equipment can mean the difference between life and death. I see it way too often in the work that I'm in. So make sure you're up to date on first aid. If someone were to go down, eating lunch at their desk and are choking, can a coworker help them? Are they trained to help them? So think about that. Think about the training. Think about the policies. Think about what kind of policies do you have for the pandemic, pandemic illnesses, communicable disease policies is something that clients are struggling with right now. Not so much the face coverings and all of that stuff, but bloodborne, I can never say that, bloodborne pathogens in the air on equipment. Do you have the right equipment? Do you have the right respirators? Those type of things. If OSHA walks into your organization today or if you have field workers that are working in the community and OSHA pulls up, do your employees know how to handle that? If OSHA was to walk into your organization at 11 o'clock today, what would you do? And would you feel comfortable with that? So a safety firm that specializes in this stuff makes a huge difference. Now, the last point on here are benefits. It's a very small thing that I'm going to talk about, but I see it way too often. And when I say benefits, I'm talking not so much medical benefits, that's important, but vision. I can't tell you the number of times where I visit an organization and I see their employees working with very small components, parts, pieces, machines. And I look and I see them squinting. I see them struggling with working with the equipment and these small components and the tools. You know, I see employees with glasses that are broken, or they're working with machines with no safety goggles, prescription safety goggles. And then I ask the owners, on your benefits plan, are you offering a vision benefit? And in most cases, 90+%, the organization does not provide a vision benefit plan to their organization, although their employees are working with very small equipment and they need that coverage. And it's no fault of the employer. I'm not suggesting that. They just don't think about it. But think about that, because I tell you, if your employees do not have that as a company benefit, in most cases, they won't get their eyes checked and they won't take those safety precautions or prescribe to those safety prescription goggles, because they don't want to have to pay out of pocket for it. So you have at-risk employees because they don't have the right equipment, because they don't have a company paid benefit within the organization. And it's just something people don't think about. So if you have employees that are older, demographics, right? I'm 51 and I have contacts. I will run into a wall if I don't have my contacts in, or glasses. So I know there are others. So as you know, what is the average age of your organization? And if it's over 45, whatever that number is, you probably should have a vision plan. Your employees, in most cases, need safety, and they need prescription glasses. So something to think about. Some of the most commonplace safety hazards are forklifts, as you can imagine, chemicals, lifting. By the way, lifting, and we're going to wrap up here in a minute. Lifting. 2 weeks ago, I read a report. OSHA came out with a study 2 weeks ago where they are beginning to see an increase, speaking of vision, an increase of retina detachments. Now, I don't mean to gross you out, but the eye is actually separating from the socket. And they are seeing an increase in these type of injuries for those companies with older employees. Older, I'm talking about safety. That's the only reason I'm talking older. I think it was 51 years old, that consistently over the course of a number of years had to lift more than 30 pounds. And because of that strain frequency over a number of years, and by that employee getting older, there is causing eye injuries. Now, I'm in this business. I'm a risk management consultant, and I never even thought about that. So heavy lifting is not only a back injury or a shoulder injury, that too, but there are other things if your employees are required to do heavy lifting. And then some of the other safety hazards are pretty self-explanatory. Electrical engineers, electrical contractors, landscapers, you're working with tools, if you are excavating, those type of safety hazards. If you are in the transportation industry, logistics, if you have a CDL license requirement, DOT compliance. DOT compliance is becoming huge right now. And you don't have to just own semi-trucks. If you own company vehicles that is over 10,000 pounds, you may be required to have a CDL license, and you are governed by the DOT, Department of Transportation. If you have company vans that carry 8 or more passengers, including the driver, for compensation, you may be required to have DOT compliance. So if that fits you, give me a call. And that is an area that OSHA and the Department of Transportation is really heavy on. So the last one that I will talk about, and then we will wrap up for the day, is VSSR. And that stands for violation of a specific safety requirement. It's an issue that a lot of employers are not aware of. And basically what that is that if a worker gets injured and the cause of that injury was because the employer did not do something that was a required safety requirement. And let me give you a quick example, a true story. This company made these huge glass panes, went for windows for buildings. You're talking 10 foot by 10 foot panes of glass that had to be carried by suction cups by 2 or more workers, taking it from one location to another. This is a true story, okay? I won't gross you out, I promise. But had a worker that suction cup on the glass, huge piece of glass, for whatever reason, the glass fell on the top of his shoe and cut his foot very, very seriously. Well, in that industry, you are required to have special shoes just for that. The employer did not have that in place, just didn't know about it. So with a violation of a specific safety requirement, above and beyond the impact on your workers' comp, the employer could be required to pay an additional 50% of the claim of that injured worker. So for example, if that claim is $100,000, the employer could have to and be required to come out of pocket for $50,000. It is a failure of an employer to comply with a safety requirement. It is an out-of-pocket cost to the employer, and it could result in the need of an attorney. You will get summoned. The state of Ohio will compel you for them to come in, and they will audit your entire facility. It's a very, very complicated, stressful process with huge financial exposure. And there's a valid application process that the injured worker needs to apply for as a result of the allegation. And by the way, there is a 2-year statute of limitation. So if a worker gets injured today, let's just say October 1st, 2020, you have to deal with that and think about it for the next 2 years, okay, as an example. So know that's why having a safety program, having a safety firm, do the trainings, making sure that they are looking around the corner for you, making sure that they are experienced in your industry requirements. OSHA, State of Ohio, BWC all of these regulatory agencies, they come out with different regulations constantly. And you as an employer, you have to run your business. You have to drive revenue. You have to do all the things you need to do as an organization. And I would also always recommend having someone else take care of your workers' comp and your safety. It really makes a difference. Okay, that's it. Hopefully that wasn't too painful. You know, what would I recommend that you do next? Well, we talked a little bit about that. Have an expert look at your workers' comp program. Have an expert come in and do a risk assessment that is just between you and that company. Do a mock audit of your organization, and they will give you a findings report, like at Sheakley. That's what we would do. We would take a look at your organization. It doesn't disrupt your organization whatsoever. And we'll do a review top to bottom, and then come back with a findings report in writing and says, listen, based on your industry, these are the things that you're doing right. Here are some recommendations that we would make, and here's your areas of vulnerability. Also, contact your TPA and make sure that they have some of these strategies in place. You know, you are now going through open enrollment for your workers' comp, and it's a great time to take a look at that. If you have any questions for me, if you want me or Sheakley to do a no-cost analysis and make some recommendations to you, we'll be happy to do that. There's no cost to you for that. And my contact information is right there. So feel free to reach out to me directly, and I will make sure I get back to you, and we can talk about your organization and your needs specifically. So with that, I will turn it over to Pam. Thank you so much for attending this session. I hope that it was helpful for you. So thank you.
Oh, thank you. And if anyone has questions, we have a questions and answer box, or you can write it in the chat. We do have a comment that Sheakley, they've been with Sheakley for many years, and everyone is top notch. And they can ask the quote unquote dumbest questions, and they're always there for me.
Oh, good. Very good. Thank you. I don't want to make this a sales pitch at all, but thank you for the comment. That really helps. So appreciate it.
And Don's contact information is there if you have any questions after this. I just am sharing my email as well in the chat box. Most of you should have it, but if you have any additional questions or need Don's contact information, please feel free to reach out to me as well, and I'll be able to get you connected.
Thank you, everyone.
Yeah, thank you so much, everyone, for coming on today. I really appreciate it. And Don, thank you so much. You always have great information.
No problem. Thank you. Thanks, Pam.
Thanks,
All
everyone.
righty.
Have a great day.
You too. Bye-bye.